I've just completed this English legal system question in less than the time that it takes on average to answer an MCQ in SQE1. See how I got on, but only after the jingle.
If you wanna be solicitors, why don't you come and visit us at SQE1 FLK1
So this is multiple choice question 20 from the SRA's FLK1 question bank. Let's have a go. 3, 2, 1. A claimant is bringing a claim against a defendant seeking damages for breach of contract. The claimant alleges that the parties agreed to an oral amendment to the contract. The defendant denies that the parties had any such agreement. The only evidence on this issue which will determine the outcome of the claim is the conflicting oral evidence of the claimant and the defendant. Which of the following best describes the burden of proof, if any, which the court will apply in deciding the issue? So it's all about burden of proof. A. The burden lies with the defendant to disprove the claimant's allegation beyond reasonable doubt. Well, no, this is a civil claim for breach of contract. The test is going to be on the balance of probabilities, and of course the burden is always on the claimant, so that's wrong for both reasons for A. B, the burden lies with the defendant. Well, that's wrong for the same reason as A. C, neither party bears the burden of proof, and the judge will order a retrial if the judge can't be sure which party's evidence is correct. Well, no, the burden of proof is on the claimant to prove the claim, so that's clearly wrong. D, the burden lies with the claimant to prove the allegation on the balance of probabilities. Yep, I think that's correct because it's the civil test, so hopefully E is wrong. The burden lies with the claimant to prove the allegation beyond reasonable doubt. No, that's the criminal burden of proof, so yeah, D is definitely the right answer.
SQE TV.
Now, as regular skewers will know, that's regular SQE TV viewers, when we look at one of the SRA's sample questions from their question bank, what we do is we unpack all the facts, we look at each of the options in turn and explain how and why we ruled them out and how and why we ended up choosing the single best answer, which we did. Here we selected option D, that the burden lies with the claimant to prove the allegation on the balance of probabilities, and I'm pleased to say, yes, D was the correct answer. So, how do we get there? So to get this answer right, you had to have a really good understanding of what the onus of proof was and what the burden of proof was in the context of the fact pattern. And the fact pattern was telling us that a claimant's bringing a claim against a defendant seeking damages for breach of contract. So that was one of the first key points. It was a breach of contract claim. In other words, it wasn't a criminal claim, it was a civil claim. The claimant alleges that the parties agreed to an oral amendment to the contract, and the defendant denies that the parties had such an agreement. The only evidence on this issue which will determine the outcome of the claim is the conflicting oral evidence of the claimant and the defendant. So clearly for the claimant to win this case, they're going to want the judge to prefer their evidence. And it's asking you which of the following best describes the burden of proof, if any, which the court will apply in deciding the issue. And before I looked at the options, I had already registered the fact that this was a civil claim, and I remembered that the law in relation to civil claims is that the onus of proof is on the claimant to prove their claim, and they need to prove it on the balance of probabilities. In other words, it's more likely than not that the evidence in this case that they are giving is to be preferred by the court. And if they achieve that level of burden of proof, then the judge should grant judgment in favour of the claimant. So looking through each of the options, why did we rule them in or out? Well, A says the burden lies with the defendant. Well, we could probably leave that here and there because, of course, we've already concluded that the burden lies with the claimant in this particular case. And then it says to disprove the claimant's allegation beyond reasonable doubt. Well, that's wrong as well. So both parts of this question is wrong. The second part is the burden of proof in a criminal case. That reasonable doubt, remember, that's the burden of proof used in criminal proceedings. We've already identified this as a civil case, and therefore that second half of the sentence is wrong as well. So what about option B? Well, you can see from the first few words it's identical to the beginning of option A, and we ruled out option A for that reason. It says the burden lies with the defendant. We know that the burden lies with the claimant, so we can reject option B immediately. What about option C? Well, the first few words, it says something slightly different, but it doesn't say that the burden lies with the claimant. It says neither party bears the burden of proof. Well, that's incorrect. We know the burden of proof is with the claimant, so we can rule out option C as well. But just before we leave option C, it's worthwhile commenting on that last few words. It says the judge will order a retrial if the judge can't be sure which party's evidence is correct. Well, if that is the case, then the claimant won't have proved on the balance of probability that their evidence is to be preferred, and therefore the onus of proof has not been satisfied in that particular case. So in that case, judgment would be awarded to the defendant. The claimant wouldn't succeed in their case. So A, B and C That's been ruled out. Let's have a look at D and E. Well, we said D was the correct answer. The burden lies with the claimant to prove the allegations on the balance of probabilities. We've concluded that because it's a civil claim. So why is E wrong? The burden lies with the claimant to prove the allegation beyond reasonable doubt. Well, they've used the criminal burden of proof there, which is incorrect. So that's the reason why option E is not correct.
SQE TV.
So to get this question right, you needed to have a strong understanding of the onus of proof and the burden of proof in different types of legal proceedings, and appreciate that it's different between civil and criminal proceedings. And of course, the onus of proof, who has the obligation, is normally on the party bringing the case or the claim. So in civil proceedings, it's on the claimant. In criminal proceedings, it's on the prosecution. And what we always do when we finish one of these videos, we give you a number of what-if scenarios. These aren't scenarios we'll give you the answer to, but they're for you to go away and have a think about how your answer and conclusions might be slightly different, or maybe the same if the fact pattern was slightly different. So what if the conflict of evidence was in a trial in relation to a claim for negligence rather than a claim for a breach of contract? Would your answer be any different? Secondly, what if the conflict of evidence was in a criminal trial and not a civil trial? Would you have chosen a different option then? And finally, what if it was a bail application by the defendant in criminal proceedings? In that case, it wouldn't be a situation where you've got a conflict of evidence. There'd be a test by which you would need to convince the court to either grant bail if you are acting for the defendant, or if you are acting for the prosecution, reasons not to grant bail or conditions for which bail should be granted. So it's a different type of test that will be displayed there. So go off and make sure you look at that, because it's slightly different in terms of how the court reaches its decision on different types of proceedings like bail proceedings. So there we are. I hope you've enjoyed this video. If you do, please do like and subscribe to the channel. It helps us keep ahead of the algorithm. Do tap that notification bell to find out as soon as our new videos drop. And please do leave a comment in the comments box, particularly if you want us to cover any more of these types of sample questions in the SRA's question bank. In the meantime, until next time, cue the jingle.
If you wanna be solicitors, why don't you